I'd like to call this meeting to order, and we'll start with our traditional land acknowledgement.
The land upon which we work, live, and sustain ourselves is the ancestral and treaty lands of the Michizagig Anishinaabe, also known today as the Mississaugas of the Credit, the rightful caretakers and title holders of this land. We also recognize the rich pre-contact history and relationships which include the Anishinaabe and the Ongwe Hongwe.
Since European contact, this land continues to be home to Indigenous and non-Indigenous peoples. As responsible community members, we value the diversity, dignity, and worth of all people.
Colonialism displaced and dispossessed Indigenous peoples of their ancestral land
and continues to deny their basic human rights, dignities, and freedoms.
We are committed to learning true history to reconcile, make reparations, and fulfill our treaty obligations to the original peoples and our collective responsibilities to the lands, water, animals, and each other for future generations.
Thank you. So now we're going to go approval of the agenda. So just everyone is aware, but just to note that it's been revised from the initial agenda. The agenda that's published on the website and what's been circulated is the agenda ahead of us. So can I have someone put this on the floor? Trustee Clark, and seconded by Trustee Bailey. All those in favor of the new agenda? So pass. So we're now going to move on to declarations of conflict of interest. Do I see any conflict of interest? None? Okay, perfect. We'll now move on to approval of the previous meeting of the Governance and Policy Committee of March 19th. So can I have Trustee Ellis put it on the floor and Trustee Cromoli seconded? Do we have any comments or questions or changes to what was recorded in the minutes? Seeing none, all those in favor? So passed. So we're now going to go on to our staff reports. And our first report is the whistleblowing policy that was presented by our acting legal counsel. It's now yours. Floor is yours.
Thank you, and through your chair. Tonight, I'm recommending for approval of the revised whistleblower policy. The whistleblower policy is an accountability process, which allows for the transparent complaint process for PDSB community members, as defined in the application and scope of the policy, to disclose any incidents of wrongdoing which may impact the PDSB, and also sets out a streamlined process for assessing and responding to such complaints. The policy also sets out a process for protection against reprisal for individuals who raise complaints in good faith. The whistleblower policy was last reviewed in 2018, so it's been a couple of years. The updated policy was conducted through an environmental scan of other school boards and their whistleblower policies, as well as internal consultation. You'll see that the new policy outlines a clear process for addressing whistleblower complaints, outlines requirements for the specific intent of the complaint, as well as requirements of the types of details that we need to process a whistleblower complaint. And so it sets out those details. Details the specific role of the Director of Education in receiving and then doing an initial response to the complaint, including determining who will be reviewing, conducting an initial assessment, and conducting an investigation as necessary of the complaint. Outlines a process for the preliminary review of the whistleblower complaint to make sure, for example, that it hasn't already been addressed in another reporting mechanism at the board, or should better be addressed at another reporting mechanism at the board, and updates the existing policy by providing guidance on frivolous, vexatious, or abusive complaints, ensuring that staff are protected while maintaining open communication. So the next steps for PDSB staff include the development of accompanying operating procedures as outlined within the policy with respect to the preliminary assessment, investigation, and communication processes for the whistleblower policy. Thank you, and I'm happy to answer any questions about this policy.
Great, and I think this is very important. So let's put this on the floor. So I think now we're going to, Trustee Bailey, would you put this on the floor, seconded by Trustee Elves? So now that it's on the floor, does anyone have any questions, comments? Trustee Elves is the first to go.
Thank you, Mr. Chairman. I'm really glad to see this come before the board. I can recall a time when when Captain Lockyer was still our legal governance officer and a similar topic arose. We have a tool which functions in a different way, but it's reminiscent of a whistleblower policy for students. It's Speak Up, Spark Change, or Speak Up, Speak Now. It's on our website. It allows students to anonymously file complaints when they see wrongdoing amongst their colleagues. Is there some type of system or integration that we could offer our staff with this policy that allow them the same level of anonymity and simplicity to submit a claim, for lack of a better word, a claim?
Thank you, Trustee Allison, through your chair. You'll see in section 3 of the policy that it does set out a process for anonymous complaints. So it's through the board's integrity counts third-party whistleblower service. So this operates as a sort of a landing mechanism for complaints to go through. It gets anonymized and then gets notification to the Director of Education. And so that way staff are not required to use their Peel email, for example, or their personal email in filing complaints. They can go through this third party service.
Thank you, through you, Chair, but I'm actually on it and I'm looking at it and I'm clicking anonymous from your organization and it asks me for my name, my employee number, my contact number, and my email address. Are those optional or is just the email mandatory? But I feel like even through an email, that would be something that could be then traced to a person. Whereas our students Speak Up, Spark Now tool, I don't believe ask for any of that.
Thank you, Trustee Elvis, and again through your chair. From what I understand, there is a requirement to put in your information as it relates to the complaint, but it gets anonymized through the service itself. And so when it's received by the Director of Education, it's there's no identifying information as it relates to individual complainant. But I'm happy to take that back and for consideration to determine whether or not how the complaint process itself works. To see if there should be a process for anonymizing even the complaint itself at the very beginning.
Through you, Chair, I would think so, because from a policy perspective, I could see how this contravenes it, right? I could see how someone's looking to be completely anonymous and this wouldn't allow for it, especially after the potential circumstance of a legal matter where there being involvement of a court, that perhaps their information becomes known, and I'm not sure from a legal perspective if that's something we could have as completely anonymous.
Right.
But that's one of the things that stuck out for me from the policy as a big potential consideration.
Just to add though, I just went on the website. There's a big indicator there. It says the anonymous.
And even if you click it, you have to put your name in.
Right, but it says anonymous from your organization. And the statement is any provided contact information is available to integrity accounts for the purpose of providing notification, allowing you to reset the password for your case. Your identity will not be shared with your organization. So that's what's there.
Right.
And when I was chair, I was involved in this piece of software. So it's like a middleman communication. But so if I wanted, you get an anonymous complaint, which I would have, you would then have some correspondence going back and forth. Well, you can't have that without an email. And so this is where the integrity account would then say, well, if you really want anonymous, make a separate email to make the complaint. But I know you can further look into it.
Thank you for.
That's really, Chair. The background I have on this is I'm actually thinking of Crime Stoppers. I believe I don't think this for certainty, but it's my understanding that actually Crime Stoppers is the only completely anonymous service that allows the general public to file a truly anonymous claim that is actually protected by the charter, so that they can't be called, the people reporting the crimes can't be called or subpoenaed in a courtroom. And I'm not sure that this offers that level of anonymity, where if something was truly egregious, that the person reporting it might not be able to be contacted. I'm just in the sentiment of this being a whistleblower policy, I wondered that. But if legal could take it back and perhaps just give us that update, maybe that would be good. But I really appreciate staff's response, and I'm satisfied with the response. I just wondered if there was a way to take it step further. Thank you.
Just let you know, the default selection is anonymous on the website, which is really good. Any other comments, questions? Yes, Trustee Clark.
Yes, thank you. Okay, just, to clear things up with that, what's it, section 4.7G, insufficient information. I've got two questions. Insufficient information says, that, it can be dismissed, right? So what actually does that mean?
Thank you, trustee, and through you, chair. This is at the preliminary assessment.
Yeah.
Review. And so often sometimes when complaints come in, they are lacking detail as it regards to, the date that the incident happened, what actually occurred, some of those incident information that we require as set out in section 4.4. And so in those instances, and again, subject to the discretion of the director or their designate, it may be found that there's insufficient information to actually engage in a review and investigation process. At this point, I'm unable to describe to you a specific example for it, but at this point, as it's a preliminary review, we're talking about very high level complaints. And so it's not a deep scrutiny of the information, but it is information that's insufficient to set out the requirements under section 4.4 and information that's insufficient to move forward with an actual investigation process because it's lacking those fundamental details of the complaint.
Okay, thank you. And through you, Chair, under H 4.7H, it talks of it respond. So much time has elapsed. How much time has to be elapsed before it becomes something that would just end? It gets to that point, and then it's over because of the time that's passed.
Thank you, trustee, and through your chair. I think that's a decision that's made for the procedure that will come from this policy. We'll have to consider reviewing, different other school board policies and procedures and determine some of those operational pieces about the policy itself. And so I think that question is an important one and could be better fleshed out in the actual procedure.
Okay, thank you.
Yeah, I know there's statutes, limitations which are keep paperwork of 7 years, or there's all kinds of different kind of things that, that leaves it open enough to leave it subjective to whatever the situation is. That's good. Any other questions or comments? So I'm going to ask this question, and it's something we don't do, but I don't know if it's right to ask this question, but we don't have any reporting on the number of whistleblower claims or anything that comes from that. And I don't know, in your jurisdictional scan, are other boards, saying in committee we looked at 5 and we found 1, or we looked at none and found none? Is that a very high level cursory report that people are using this as a vehicle to bring things to the attention of the board?
Thank you for the question, Chair. From what I understand, we did a jurisdictional scan, not just of school boards, but of various organizations and their whistleblower policies as well. Some organizations do have a high level summary that comes sort of at the end of the year, for example. I will have to go back and review the different school boards to be clear about what their policies say. And I'm happy to do that and get back to you about which school boards have that process.
Thank you. I think if you have that information when we bring this report to the board, then we can maybe then either attach it as an amendment or make a statement that just a friendly statement says, maybe once a year we could just have a report. Because I think it's important. I know when I was chair, I saw the various things happen. So it's important for our governance trustee, 100%, I think, know what's going on. Anyway, that's just my belief, but you're going to prove it wrong, obviously. Thank you. And I think that was my last question. Oh, Trustee House, you have a question?
I apologize, Mr. Chairman. I know we have an order. Thank you for allowing the question after I asked. Just curious, and I don't even know if this is applicable to scope, but it just popped in my mind. Through the Freedom of Information Act, would the reports filed by some of the employees from the PDSB be accessible by the public?
Thank you, Trustee Alves. I think I'll have to go back to the legislation on that, just to determine, because confidentiality pieces, redaction pieces, there's a lot that goes into FIPA, and so that's another thing that I can go back and review to determine whether or not. In my, I want to make sure that I read the legislation before I respond to that question.
Through your chair, I would say that would be a critically important piece to have outlined in the policy. If that information is FOIable, it should be outlined in the policy before we accept it.
Yeah, I think it's an assumption. I think we can either clarify it or do it, put it in an amendment when it comes to the board, for sure. That'd be great.
Great questions, guys.
Yeah. Any other comments or suggestions? Okay, so it's on the floor. So I'm seeing, let's go to, yes.
Assuming they make it.
Yep. Yeah, we'll approve receipt of this report, and we'll see this at the board table at our next board meeting. Will we see this next week? Is it next week or 2 weeks? 2 weeks. 2 weeks. 2 weeks. So we'll see it in our board meeting in 2 weeks, and then we can have those questions. I appreciate that.
Thank you.
Thank you so much. Thank you. So now we'll move on to 7.2. And it is concussion and prevention, protocol, which is really important. And I see that we are going to have, who's presenting this today? We have Masuma and both of you.
Good evening, everybody. Laura Shabar, Superintendent of Curriculum and School Improvement.
Okay.
The report will be presented by Coordinating Principal, Sambol Kokap, and I will turn it over to her.
Good evening and thank you. Through you, Chair, I'm pleased to share the annual report on the implementation of the Concussion Intervention and Prevention Policy. The policy aligns with PPM 158, the Education Act, Rowan's Law, and the Ontario Physical Activity Safety Standards in Education, also known as OPAS, their concussion safety standards, guidelines, and protocol. This policy requires us to provide an annual report on the implementation activities related to concussion prevention and intervention, and the report is included in the package this evening. The Curriculum and School Improvement Department provided professional learning for staff, which was completed on the first professional learning day of this school year, and training was recorded on our tracking system for completion. Professional learning was provided for administrators through the principal and vice principal associations on the policies and procedures. Codes of conduct for concussions and relevant training were delivered to coaching staff at various elements of the school year and related to the activities that were taking place. Concussion education was provided for students that participate in intra and intramural sports. The plan next year is to continue to provide training for staff on concussion prevention and intervention, and continue to track and manage suspected concussions for students. That's the end of my report, and through you, Chair, I'm happy to answer any questions.
Thank you, Sambol. So we'll put this on the floor. Trustee Cromoli, seconded by Trustee Clark. So do we have any questions or comments for this? Yes, Trustee Bailey.
Through you, Chair. On an average, in our schools, how many concussions would you say do we have per year?
That is through you, Chair. That is a difficult question to answer. We do have a lot of suspected concussions. So every time we have an incident that results in any incident where a potential head injury is involved, we initiate at the school level a protocol to diagnose a suspected concussion. So we do have a large number of initiated suspected concussions where we initiate the protocol and go through the procedures outlined in the concussion procedures, where we go through checklists and then determine if there's enough evidence there to communicate with the parent and suggest medical contact for the family doctor to officially diagnose a concussion. So there's a large number which indicates that people are following the processes. And then in relation, there's very few diagnosed concussions.
So parents fail to follow through.
No, any slight suspicion of a head injury results in us initiating, where we go through the procedures of seeking out whether a medical intervention is required. If the parents are following through, my observations have been in my conversations with families, that the parents are following through and they do take the advice that the school suggests.
Can I just interrupt? Apparently the live streams went down, so we're just gonna pause.
It looks like it's like a major server issue at Vimeo.
Sorry?
There's like a major server issue at Vimeo.
It's a major server issue?
Yeah, I can't imagine it going back.
It's
been down for about like over 5 minutes.
okay, but we are recording.
We are recording though, so.
And so we
are open.
are open to the public.
Yeah.
So we'll carry on. Do I have approval from the board to carry on? Yes, okay, sir. Okay, please proceed. Sorry for the interruption.
So is it that there's not a diagnosis? Okay,
Yes,
okay.
it doesn't always result in a diagnosed concussion by a medical
Okay. So you're not able to give us the number of diagnosis?
No.
Thank you.
So I'm gonna follow on that question. Normally I'll wait till the end to talk, but just following on trustee Bailey's comment. So we track the number of incidences that we recommend parents should. Do we know that number?
Through you, Chair, schools track individually through their initiated procedures, the number of suspected concussions, and then they continue to track. So schools would have that data.
Okay.
Schools would have the data of number of suspected because they tracked through paperwork, and they definitely track through paperwork because there's a paper procedure that's required to go through the process to determine if a student has a concussion.
And then if it gets suspected on all cases, the parent says, yes, Johnny or Sally or whatever has a concussion. Do we record that in that paperwork?
Yes, because there's a tracking of the progression of a concussion till the student is able to return to learn or return to play or both.
Right.
Yes.
You know, and I'm quite familiar with my always went through that. But we don't do that centrally.
We do not have the mechanisms to track all the diagnosed and suspected concussions. We are in the process of capturing data through our new system, Peelschools, this year. But I would not say that at this point in time, the transition to Peelschools is the data that is recording there is fulsome to be able to paint a picture.
But
we're on our way to developing those systems.
Is that a goal that we will have essentially?
Yes.
Perfect. Thank you so much. Sorry, trustee Gamal.
Thank you. I know trustee Davies, you also had your hand up. I did have my hand up earlier, but if you'd like to ask your question first, that's okay.
Just from a liability through your chair, for a liability, every time that we fill out this form suspected, we do inform the parents, just say, listen, like, we're not diagnosing, we're not saying anything. We want you to let you know about this incident. And we cannot diagnose a concussion. We cannot tell you what to do. But then we go either recommend, see the doctor, or we found that according to what our procedure, there was no concussion.
Great question. Through you, Chair. So the protocol does require communication with parents, and educators are not in a position to diagnose a concussion. They can only work through the procedures that are outlined, and they give the outcome of those procedures. And depending on what the outcome of the checklist is, that's on the procedures that are standardized across Ontario. But those results are provided to the parent, and that's where a recommendation to seek medical attention or not comes from.
Perfect. Thank you very much. I'm very relieved by hearing that.
The procedures are standardized, and we recently updated in the last couple of years our procedures to align with the Ontario standards. So our procedures, we're not making them up. They're standardized and we follow them standards.
Thank you. Trustee Ramon.
Thank you, Chair. So when the training, is it mostly focused for staff who are dealing with physical education and sports related, or what are all staff receiving the training when it comes to concussion protocol?
Excellent question. Thank you for that question. So all of our staff members go through training for concussion prevention at the beginning of the year. It's necessary along with the other standard safety protocols that we follow. And then in addition, for every coach that coaches sports or activities where there are higher risk for concussion, there is additional, almost more intensive training. There's a concussion code of conduct, a more extensive understanding of the procedures and that need to be followed. So everybody gets training, but then there's a more extensive version that coaches have to go through before they can coach a high risk sport.
Okay, no, that's very helpful. And follow up through you, Chair. When a concussion has been confirmed through diagnosis, we know that there's a wide variety of how long it might take for somebody to recover from that. It might be days or it might be literally months, right? And regression is something that unfortunately is unpredictable, but can happen. What sort of protocol do you have in place to make sure that any staff members who might be interacting with a student who has been diagnosed with concussion understand what is necessary to help them through that process? Because again, recognizing it can take months and trying to hurry forward the process can actually lead to regression and then a longer recovery process.
Thank you for that question. So our procedures outline extensive processes and they're listed in the appendices. So one of them is a tool to diagnose a concussion. And when a concussion is confirmed, there are additional tools available from the procedures, which are managed by the administrator at the school, where there's ongoing communication requirements between the family, the child, and the administrator on the progression of the concussion, so that the student can return to, let's say the doctor recommended that they're limited computer time, or like if it's return to learn, then that communication is happening with the educators and the staff who work with those students. And if it's return to play, then that communication extends to the coaches and the extracurricular activities. And so they're two separate, depending on the extent of the concussion, whether it's return to play, return to learn, or both. And so there's ongoing, those appendices that are included in the procedures include both. And it requires you to work through those procedures. For a return to play, often a doctor's note is required to demonstrate that you would return to a high-risk sport, for example. And a return to play is ongoing communication with the family, who is continuing to seek medical attention to determine what the recommendation is in terms of the educational outcomes. The accommodations that are required to ensure learning is still available, but accommodated to support the recovery through a concussion. I hope I answered your question.
Yes, just one more follow-up. I think my particular concern is about the return to learn, because I think there is a lot of misunderstanding about what somebody with a concussion is able to do. And somebody might think, okay, well, you can't look at a screen, but why can't you write something? Or I don't understand why you can't just sit quietly at a desk, or I don't understand why you can't be here all the time, or why can't you take the spelling test? And I think there's a lot of misunderstanding about what recovery from concussion looks like, and that misunderstanding can be very challenging for a student who is going through recovery. So I'm just, I'd love to learn more about what that looks like to ensure that students are being supported as they are coming through that. Not speaking from any personal experience.
So through you, Chair, the educator or the administrator takes direction from the family, who is liaising with the family physician around the recovery process and what that looks like. So there is an expectation that families are communicating with schools on a regular basis through the progression. So a student may not come to school. A student may come to school for half days. It might be no screen time. It might need quiet moments. There's different accommodations, and we take that direction from the family who's getting that information from the family doctor who's monitoring the progression. So that usually happens in like a few weeks' time, where you're checking back in and saying, how has this shifted? Are we working towards recovery? Is there regression? What does this look like?
Okay. Thank you. I'd love to follow up with you after, if that'd be okay, just with some further questions, but I really appreciate all your help on this. Thank you.
No problem.
Any other? Yes, Trustee Clark.
Thank you through you, Chair. Okay. What is the tipping point that creates a, that starts the process of, determining that something is a potential concussion. Like, is it like something like being hit in the head with, say, a paper airplane, or is it a basketball, or, falling down on the ground? Thank you.
Thank you for the question. So through you, Chair, in the procedures, and I don't have them memorized, but in the appendix to diagnose a suspected concussion, there are some initial questions. Usually it requires contact with the head with something, whether it was a bump, and not that it has to be a visibly seen bump, but like some contact with the head, either the student's reporting or it was seen or reported by somebody else, and then a series of questions are asked to the child. And you kind of work through there to see what's the functionality. And sometimes it takes time for a concussion to manifest. So we have to take our cues from the student, where there's monitoring depending on how significant the contact with the head was. So if a paper airplane, for example, hit a head, but the student gets up and they're playing and somebody asks them, are you hurt? Do you have any head pain? No one's probably following up with that. But if it was a ball, then there's regular check-in kind of just to say, and staff are pretty diligent about the concussions. They understand through our training that it's very serious. And so even if they have a moment in the moment, there's usually a check back saying, how are you feeling now? Is there a headache now? And we have to take our cues by monitoring the student because we know that concussion doesn't always manifest in the moment. It might take some time for it to show up.
Thank you so much.
Hope I answered your question.
Thank you. Any other questions or comments? So thank you very much, Laura Sumbel, for the. We have a question in the back. Sorry. Yes, Shauna.
Hi, thank you. Through you, Chair. I just want to add for awareness that our concussion procedures are available on the public site on the board bylaws and policies page. So if you wanted to see the appendices that were referenced and sort of the tools for diagnosing a suspected concussion, they are available publicly.
And thank you, Lashana, for that, because I think this is very important. As a parent, others who've gone through it, it's one thing to say you have a policy. Well, what are you doing? And now you have the whole procedure, and you go through it. And as you said, concussions can come later, and sometimes it can be very mild, and then you concuss yourself the second time, and that's when it gets problematic. So. Thank you so much. So all those in favor of the approval of this policy? Okay, so passed. So thank you. So now we're going to go to 7.3, and this is going to be right here, occupational health and safety policy, and I believe that is going to be led by Ms. Suma. Am I correct? And you're online? Yes.
Yes. Thank you, Chair. Thank you, Chair. Good evening, everyone. Today, I'm presenting an annual update to the PDSP's health and safety policy in accordance with the Ontario Health and Safety Act. The Act is a crucial piece of legislation designed to ensure workplace safety and health standards. It mandates employers to provide safe working environments free from recognized hazards that could cause harm to the employees. Under the Act, employers are required to review their health and safety policies at least annually. Within the context of PDSB, all consultations with relevant stakeholders have been conducted and changes incorporated where necessary. The review has yielded a few updates to the definitions, particularly with workplace harassment, workplace sexual harassment, and the provisions for electronic postings of certain documents affecting sections 3.2, 3.6, 3.7, 5.2 and 5.9 of the policy. This is to also align the Act with the existing definitions that exist under Bill 168 and certainly the Human Rights Code. So this really aligns the three legislative pieces on the definitions of workplace harassment and certainly workplace sexual harassment that's now harmonized across all three acts. Regular reviews help maintain a safe working environment and ensure compliance with legal requirements, which is what this review has yielded. Upon approval of this policy, and by way of communication, we'll be posting this policy on both internal and external board websites. We'll continue to review all internal procedures to be in compliance with the updates within the policy, and then continue to develop and administer training materials and programs as necessary, required to be in compliance with the policy. With that, that brings me to the conclusion of my presentation. I'm happy to field any questions.
Thank you, Amasuma, who's our Executive Officer of Human Resources. So let's put this on the floor. I think where did I leave on? I think we're at Trustee Bailey. Can I put this on the floor? Trustee Alves, would you second this? So do we have any questions about the policy that was presented to us? Seeing none, though, all those in favor of approval of this policy? It's passed, and we'll move on to our next one. So that will be 7.4 in this board and committee meeting schedule, and I assume this will be presented by our governance officer. Just to let you know, when I call it on the website, it may be 7.4 in the agenda, but the report, when you click on the link, it says 7.5.
Thank you. Good evening, and through the chair. Tonight, I'm presenting to the committee the 2025-2026 board and committee meeting schedule. The meetings are scheduled in accordance with the Education Act, applicable regulations, our procedure bylaw, and our committee terms of reference. The board committee schedule also mirrors that of last year. And we have two views attached to the report for you. We have a list view of committee days and a calendar view. And I am seeking approval for the proposed schedule. Thank you. I'm happy to answer any questions.
Okay, let's put this on the floor. Trustee Famoli and Trustee Clark seconded. Okay, any comments about the schedule? Yes, Trustee Bailey.
Last year, when this calendar came out, I raised concern. I was clear to state that we create these dates. And I was clear to state that I work on the third Wednesday of every month. Trustee learning sessions were booked on the third Wednesdays of every single month. I was not able to attend a single trustee learning event in person. I got no value of any of this year's learning for trustees. I have noted again, trustee learnings is on the third Wednesday in 2025-2026. And I don't understand why it was done. I am not available 9 days in the year, 365 days in a year, and only 9 of them are not available. And out of that, there are still 5 of them in this calendar. Can I have an understanding of that, please?
Thank you. Through the chair, last year's schedule was my predecessor would have been involved in creating that schedule. However, I'm happy and open to suggestions. If you'd like to suggest other dates before the committee here, we can definitely incorporate that for moving forward.
There's only 9 days I'm not available. Any other days, I attend everything. I am at everything, even committees I'm not on, I attend.
Yeah, I just had a comment, and I hope you'll work together and solve this. But it gets complicated because we have a board meeting on the fourth Wednesday. We have fiscal planning on the first Wednesday. Then we have curriculum and governance on the Tuesday second. So it can, and SEAC. So this is where it is. So I'm going to let the two of you solve it out. And it is not like we have a number of days. We don't do Mondays and Fridays. So it really limits the time. So I'll let the two of you just work something out which works out, and we can maybe amend this. We can pass it at this time and then amend it when you come up with something. Because I think a lot of people would like to have the schedule in place, or do you want to defer it to another meeting?
Through the chair, it is the will of the committee.
Chair, could I just offer a comment?
Yep, please do.
Okay, so Carla, what normally schedule normally take a look at a lot of stuff, including our fate days, those red dot days, and so forth. It takes a
Those
look at a
don't,
lot of stuff.
those does not
Yeah.
impact us anymore.
So it is not, and it's not an individual thing. It's what's best in the interests of majority of the board and so forth. So needless to say, it's nothing. The schedule is nothing against one individual trustees. So as I
But if
told you
one
before.
individual,
Wait a sec. This is.
Okay, no,
okay.
let me finish speak, please.
Yeah, that's what I said. One
Yeah,
person at a time.
right. So what has happened is that if there is something that affecting one individual trustees, there is, for instance, we have an entire board of trustees. That needs to be brought to the board. You and I have spoken about this, and I said I'm going to look into see how we can maybe move around a couple of dates to accommodate your schedule, so that you are able to participate. Also, secondly, for all the trustees, information session, those are recorded there on the trustee portal, so trustee can able to go in and able to understand clearly. And if you have question or concern that whatever you don't understand, you can bring that to the attention of the chair or the governance officer to help you with clarification. So needless to say, as I state before, I'm willing to work with you to see how we can accommodate your schedule. It's I will tell you that it's very hard to change everything to accommodate one individual trustee, but I am willing to work with you and our governance officer to make sure that we can make sure that as we move forward, there's opportunities for you to be able to attend those sessions. Just want to say that. Okay, thanks. Thanks, Mr. Chair.
Okay, thank you, Chair. So it goes back to my initial comment. I think it would be best for Trustee Bailey to talk to our governance officer and try to find more acceptable times and see if we can do that with the board as well. And so my recommendation, but it's, if you want to put a motion, Carla, or someone want to put a motion, we could pass this and we're not talking till October 15th. So there's lots of time to, come back with a change to this at some point in time. Does that work for you?
sorry, repeat what you're saying.
Sorry?
Repeat what you just said.
What I just said?
Repeat what you just said.
Is that okay with you?
To do it.
Okay, so, there's options for you. We can pass this this latest calendar for trustees and meetings and stuff. And then you can work with our governance office to find and see if you can move the 4 dates to something that may work for you. And then we see if other trustees are not affected. And then we go do that. The first date is October 15th. So we have a lot of time between now and then to do that kind of work. Or you can put a motion and try to put it some other date. But the problem is, your date, and then we have to worry about everyone else, and we'll start putting individual dates. So my recommendation is to try to work on it with our governance officer and see if we can say, hey, these dates work better. We can move it to a Tuesday, for example, right? And then we just send an email out to all trustees, is Tuesday, the 14th work of October, and then they go, all yes, and then we'll make a change. It's trustee learning. It's not, trustee learning is different than board meetings. What I'm saying, the board meetings, the public's involved and the whole process behind it to support it. Trustee learning process is just our internal stuff. So we can manage that more internally with, maybe Ariel can take that responsibility and coordinate that with trustees, because that's what we really want to do.
I think my frustration comes, it's not the first time I've stated it. It's something I've brought up from last
year. 100%. And as the governance officer stated, that was done by someone else who didn't hear those, couldn't hear those
It's not
comments,
against you, John.
right? So the solution, here is to just work with our governance officer L'Oreal to try to find something that works for all trustees, right? Is that acceptable?
No, but I'll go along with it.
That's not an appropriate answer. It is or it isn't.
Go along.
Okay. So any other comments or questions? Okay, then we've had this on the floor, so a vote for acceptance of our board committee meeting schedule. So approved. So we're now going to go on to trustee expense policy. And so this is being brought again to the board. I'm going to turn it over to our governance officer. And I think our chair would like to add some words to it after your comments.
Good evening. Thank you. Through the chair, I'm presenting tonight an overview of the trustee expense policy regarding meeting attendance. This update has been prepared in response to trustee inquiries regarding meeting attendance payments as outlined in the trustee expense policy and trustee honoraria policy. The purpose of this report is to provide an overview of the current meeting attendance payment framework for trustees. The Ministry of Education sets legal limits on school board trustee honoraria through the Education Act, its regulations, including Ontario Regulation 35706, honoraria for board members. The trustee expense policy provides trustees with a meeting attendance amount of $50 per meeting for attending any meeting of the following committees of the board, so long as a trustee is a member of said committee. This includes Budget Development Committee, Discipline Committee, Negotiations Advisory Committee, and the Student Transportation Appeal Region Committee. This policy also states that each year the board may review all committees and task force that have trustee membership and determine if the meeting attendance amount is sufficient, and if any other committee or task force attendance should become eligible for a per meeting amount, or if any committee or task force should become ineligible for the meeting amount. Current and relevant legislation was reviewed and found that Ontario Regulation 35706 states the following. The attendance amount is an amount that does not exceed the attendance amount limit of $50. And the attendance amount may be paid to a member for attending any meeting of a committee of the board that is required to be established by an act or regulation made under the act. Tonight, we are recommending that the meeting attendance amount be reviewed at this time to determine if it is sufficient. Thank you, and I'm happy to answer any questions.
So let's put this on the floor. Thank you very much. Trustee House and second by trustee Tamoli. So I think trustee Green online, do you want to say something? Because you.
Yes. So good afternoon again, Mr. Chair, and to my colleagues that is in the meeting tonight. This is here because trustees over the last little while have been attending various different meetings. The boards, the meetings are very long oftentimes, and let me use discipline as one of them, that oftentimes we're seeing trustees are spending 5 hours or more attending discipline. Some trustee works. So some trustee have to take time away from their work to do these, to carry out these responsibility. When I look on the amount payment, it fall under, is it sufficient to suffice the time that trustees take away from regular business or duties to attend and to carry out these duties? In speaking with ministry would say, is this gonna help trustee to carry out their job and to do their job better? If you look at it right now, when you look at it, if you break it down at $50 at 4 hours, I'm not a mathematician, but I so happen to have my calculator right in front of me, and if I divide that by 4, it is less than a minimum wage. I don't believe that at this time it is fair trustees, and therefore, because of many conversations that I've had with ministry, I believe that this is it is insufficient, and I would like to move this. We try to do it, but again, we were advised by our policy and governance folks that we need to make sure that we bring this to policy for approve so we can move forward with it. So that's the reason why it's here tonight. And I'm asking trustees to take what have been said into consideration, and so we can move this forward, so we can support trustees who has to take these times from work and so forth to carry out their board duties and function in a reasonable manner. And when we also look at finally, when we also look at come September, our board, all our committee meeting is going to be in person. So I want to also think about our trustees and also fairness in carrying out their duty. That's why this is here. Thank you. Appreciate it, and appreciate your support for it.
Thank you, Chair. So I'll open up first Trustee House.
The Chair, I have a few questions. I'll be quick. But the first is, so I am one of the trustees that sits on discipline, so I appreciate Chair Green's efforts here. I think he's absolutely spot on. But my question for you through you, Chair, is likely for legal or governance or both, because I know we're looking to amend our policy, but the Education Act note 7.1 that the maximum is 50. So are we contravening the Education Act by going to 100?
Yeah, please.
Thank you. Through the chair, that would be staff's position, yes.
That we are contravening the Education Act.
The regulation states a maximum of $50 per meeting.
Through you, Chair, can I get the legal opinion on that?
So if I may,
Please.
if I may,
Trustee Green.
Yeah.
Okay, first of all, let's deal with Lucas's question. So
yeah, that's that's what I would like to answer.
Yeah, well, I think we're gonna have the board acting lawyer, counsel here.
Okay, all right, okay. Go ahead, go ahead. Yeah.
Thank you.
Thank you, Trustee Alves, and through you, Chair, it is staff's position that the current policy contravenes the regulation, which sets out a maximum limit of $50. So staff's recommendation is to review the policy and align it with current legislation.
So 50.
50.
Understood. So we can't do the 100.
Well, so I'm going to jump in. So item 6.8 has 100 for 4 hours more meeting.
That would be 8 hours.
Sorry? No, but I'm just saying, is that in the policy? It's over 4 hours, we can charge 100?
Correct. Chair, I think the current trustee expense policy states under 6.8 that meetings over 4 hours amount to $100. That policy was created before my time, so I'm not quite sure of some of the discussions around why that policy was created, but upon a strict reading of the legislation, the maximum amount is set to $50. And so our staff's recommendation is that the policy be reviewed and aligned with what's set out in legislation.
Okay. Now, the other thing I heard when our governance officer, sorry to interrupt, but our governance officer talked about every meeting, not just the specific meetings that we talk about on our board. You talked about discipline, budget committee, etc. While when you read the act, it seemed like every meeting got $50.
I'm not sure.
So we can't.
Including this one?
So please.
Through the chair, I can reread that.
Yeah,
portion
so-
if it helps for clarification. So the regulation regarding that says the attendance amount may be paid to a member for attending any meeting of a committee of the board that is required to be established by an act or regulation made under an act. And our policy, we have adopted those for mentioned earlier.
So it's not that limit, man.
Okay, so that clarifies that it could be more. Clarify, it could be more than what we put in our policy. Okay, so now I'll let you go.
Thank you. Through you, Chair, I would say.
Hold on,
sorry.
she needed to answer.
I my question, my
Hold
follow-up is for legal. Through you, Chair. So my follow-up for legal would be, my interpretation of that, and I'll let legal confirm, is that that's not regarding our statutory committees. Those are committees that we are required to create by process of the nature of the role. So example would be not mentioned, but a committee that was created, audit committee, right? If an audit committee ran more than 4 hours, that's not like a business as usual committee. Or I'm wondering if we created like, we were discussing a potential committee a few weeks ago, but I'll let legal respond to that. But just for clarity, so the staff's position is we shouldn't do 411. I support, like I agree with Chair Green. I think we should be able to expense it, but I want to be certain that if the ministry is saying we can't, we can't.
All right, thank you, Trustee Alves, and I think that this is why the suggestion is to review the entire policy, just to make sure that it aligns with the legislation. That can include a review of sort of which committees are set out in the policy to just align with which ones, take that $50. This policy was before my time, so I think I'd like to take the time to review it, and that would be my suggestion to align with legislative objectives.
So do I hear a motion?
Oh, not yet, Mr. Chairman. Thank you, Mr. Chairman. Through you, sir. So my last questions, I didn't mean to get derailed. That took a little bit longer than I had hoped. But the other two questions I have, I noticed these are probably typos, but if we're going to, my spidey senses are tingling for a motion. So I think if we're going to look at that, I also noticed that for the communications policy, there's mention of the, trustees want to produce communications assets to deliver in constituencies, that those products need to be approved by the chair, which is our current chair, Mr. David Green, great chair, but also a executive lead for communications and public affairs. And I have been through our corporate structure time and time again. We don't have one. We have a senior manager of communications and public affairs, but no executive lead. So that would need to be amended. And I would like to know in the review if the trustee allocated expenses roll year over year the way some of our budgetary expenses do, i.e. can we roll professional learning, communications, discretionary account, and what doesn't roll?
I don't understand the second question, so we'll start with the first question, so that we understand. Okay. Sorry, Trustee Green. Sorry, Trustee Green. Well, just can we, when we ask questions, just so clarity, it's really good to just ask one at a time. So we can talk to one question at a time and then clarify it. So can you do your second question? So I think we all understand.
Yeah, yes, sir, Mr. Chairman. Apologies for the jumble of questions. I was trying to keep less time.
No, I know.
So my second question was just regarding the expenses available to trustees. An example of that would be the professional learning expense allotted to trustees year over year. If we could find out which of all expenses or allocation amounts that are available to trustees, which roll over year until our fourth year. I was thinking the example I provided was, the professional learning allowance, for lack of a better term. Would that $2,500 a year roll over? Example, a trustee in their fourth term perhaps doesn't do professional learning for 3 years, but there's a bit of an expensive course in the fourth year, and that trustee decides that they want to do a governance course to better help them.
I think we can answer that. Our governance officer.
Through the chair, staff can definitely take that back and provide some more details.
So on the heels of that.
Okay, sorry.
I can answer that question, Mr. Chair, if you want.
Well, we just had an answer. Okay, please answer it if you can answer it.
Yes, we have a number. We already have policies in place and which one of our allocation can be rolled over. And I think Trustee Hav, speak to Associate Director Gill or Tanya Alashe. They will give you all that information. We already have that information for trustees. Thank you.
Thank you.
So, and they have it, but I think it would be nice to bring it back when we go do to your motion. I assume you're going to do a motion.
Yeah, so through you, Chair, Mr. Chairman, David Green, thank you very much for your response. I appreciate it. The reason I'm asking, just for clarity, is because in the fact that this is coming with an update for part of the expense, I just thought it would be good for it to be outlined as it relates to the Education Act, because while, we might have a limit, the Education Act might allow us to perhaps roll over it. Maybe we don't for some. I know we don't for some, but I'm just giving the general question for the committee.
You have
Now,
a motion.
A motion coming from this, through you, Mr. Chairman, is that staff take this back and apply the appropriate review and bring it back to the, when convenient, when appropriate, to a following governance meeting in the future, where we can confirm the $100 allocation, of which you,
It's a
Mr. Chair,
$50 allocation into what?
into a $100 allocation for governance.
No, I think, let's make the motion very simple. Let's just refer it back to the staff to review the $50 and $100 meeting qualifications.
And the through you, Chair, the other comments that I made regarding the expenses.
That's a lot of stuff, but okay. Is that okay? We're put that all in motion?
Yeah.
Okay.
Cool. Is staff okay with that?
Okay, now, so do you have a seconder of this motion?
LaShonda has a question.
Okay, hey, I know, but you
Sorry, go
can't
ahead.
put the motion on the floor.
I don't have a
So
second.
trustee
but it's-
Clark, puts it on the floor. Now, I give you opportunity to speak to your motion, but I think it's pretty self-explanatory.
I'll just do a quick 30-second. The reason I'm putting the motion on the floor is because I think that we, especially with our new Minister of Education, who has been very vocal about boards and their fiduciary oversight, that we just confirmed that our legal and governance officers don't have any issue with us making that adjustment, and that it doesn't contravene the Education Act. And that I think it would be helpful for us to have identified in our policies which budgets roll year over year.
Thank you. Now I'll turn you over to LaShanya. LaShanya, you have it. Oh, my.
Excuse me, through you, Chair, just to clarify. So we're looking into the attendance amount as part of the trustee expense policy. We're looking into housekeeping amendments. Regarding sort of changes in position titles within the organization. We're looking into rollover amounts.
That's it.
Okay.
That's it.
Thank you.
Great. Thank you. That's, I think, it's motion. Yes. Trustee Vermolli.
Thank you, Chair. So I'm an alternate on discipline, and I sat on discipline last year, and so I understand the spirit of this, and I know that we only implemented this $50 honorarium, I think it's about 2 years ago, because it didn't used to be there. And I understand why. I know it's a challenge to find time for meetings during the workday. That said, I get it, but I also do feel that it is part of our responsibility as trustees to sit on committees. This is part of our job. And I know that it's challenging to do this during traditional business hours for a lot of people who are elected members of this board. But we are not required to sit on discipline. If that's not the requirement, right? We can opt into committees that work with our work schedule. And I know that those meetings are getting long. I understand. It would be great if we didn't, see days where there's so many of them stacked back to back to back to back, because there shouldn't be 5 hours of discipline hearings, because I've been through some of those and those are really, really tough. But, and I think that's emotionally draining more than anything else, right? When you get to a point where you've had 5 hours of discipline, it's hard. But I feel really hesitant at a point where we're spending more money to pay people to go to committee meetings, because we're not paying for every committee meeting. This is part of our job. So I have to say that.
Right, yeah. So I appreciate the comment, but the motion, and to talk to the motion, is to send it back to align the recommendation to the Ed Act. For example, we just found out, we believe, there's $100 when the meeting's 4 hours, when we're only allowed 50.
We're just confirming.
So they're gonna go back and then bring everything back to it, and then you can have that great conversation of that we shouldn't get paid for any. But we found something that needs to be fixed.
Well, I'm a big fan of confirming things with staff, and I would just knock it out entirely anyway. But yeah, and I've never claimed it myself, but I think that it's good to get the information and then we can go from there.
Yeah, thank you, Trustee Davis.
Yeah, having sit on the discipline committee for a number of years now, I just need everyone else to understand that you're given a package of 30 to 40 pages per hearing that you have to go through. Okay, so you read that through. Okay, the chair has a script that he has to follow / have memorized for every different hearing. So I was wondering if there was a way to look into, let's limit the number of hearings per meeting. That would be my, because I'm really feeling that by the third and fourth hearing in a day, we're not following procedural fairness. How can you expect someone to read that much and have that much in their head while they're going through this? It's ridiculous to have more than 3 in a day.
Right, and I'll turn it over to governance officer shortly, but please, we can't all be talking. Okay. So what's your point of order?
Sorry, Mr. Chairman, I apologize. I agree with Trustee Davies' sentiment, but this
That's not point of order.
the point of order I'm calling is with the point Trustee Davies mentioned has nothing to do with this motion. This is the
That's not, the point of order is if he did something that is in a meeting context, not following the process. So he's allowed to say what he says. You can argue when you close the
sorry.
motion.
Well, I'm sorry. I thought we had to call him first.
Okay, so again, trustees, just a clarification, just so you understand. You talk to the motion, right? And if you disagree with his comments about the motion, you so if you want to have a point of order, it's when a procedure of a meeting hasn't been followed or some outrageous comment has been made, right? That's the kind of when you point of order. So I just want to clarify that.
That was not a procedure.
And it's all learning opportunity, just like we have in these committees, not the board committee, we have more than one opportunity to speak. So someone may bring up a good point. Okay, you may want to counter that point and you hadn't thought of it. You only get one chance when you're at a board meeting. So we're a little more flexible in how we talk on stuff. So
right. And I was just getting around to my point is that, this 2 hours and 4 hours, there should be any way that a discipline committee hearing should take anywhere near 4 hours. They're 45 minutes in length each. Hour and a half maximum, we're done. And that settles all the arguments. So it's $50. You got 2 hearings, you're done. That's all. Sorry, that's sort of where I was going, Lucy. And I,
we're talking through the chair, please.
Yes, Mr. Chair. Yes, 3.
Okay, and only one person talks, and that's how we go. So I'll just do it. I think the regulations, we may want to try that, but we have a requirement for a time on which we have to do it, and I'll pass that over to the governance officer. So sometimes, if you push something to next Monday, and you may have 6 because you get a whole bunch in between a time schedule. But I'll pass over to the governance officer.
Yes, thank you through the chair. I was going to state the same. There is timelines required under legislation, and the student achievement and wellbeing team could speak to that more, but we can also provide those details in the report back.
Okay, but through you, Chair, the main point of a discipline hearing is procedural fairness. And what I'm trying to say is that my years on discipline, I have found that the level of procedural fairness declines after 2 hearings in one day. So what I'm trying to say is if we have to have them on a Monday and then again on a Tuesday, fine. But I'm just concerned that we're not following what the meeting is about, and that is procedural fairness.
So, I'm sorry, I'm going to throw an idea for you. Is that creating, if you have 2 meetings, you get paid twice? Sort better than having 4 meetings? Same for the same 50? We can think, I'm just food for thought. Yeah, okay, so before we're going to close with you, and you get to close your motion. So anyone else want to make a comment or questions around this? Carla?
Not on this.
Put your mic on, please.
Sorry. Through your chair, not on this topic.
Well, we can only talk on the motion. That's what we're at right now. Okay, thank you. So
Through you, Mr. Chairman, thank you. So just to clarify my earlier point, I appreciate your lenience and your walkthrough. The point I was making was in relation to Robert's rules, and it wasn't criticism of Trustee Davies. I actually support what Trustee Davies is saying. He chairs our discipline committee meetings, which I sit on. Does a great job, and he's absolutely right. Some of these meetings have taken us 6 hours, and we had notably one package with very little time to review that was 75 pages. The point I was making was that under Robert's rules, all discussion should be germane to the motion, germane being a requirement to find that all debate must be strictly directly permitted to the pending of the motion, and that if a member starts talking about something adjacent or tangible to the motion, it violates the rules of the debate. But I appreciate the clarification. In summary, I think that having staff review this is a good thing, because if we can confirm that we can go to $100, I support Chair Green 100%, because as Chair Davies mentioned, I have sat on that committee for 7 hours. I started at 2 and finished late in the evening, only to have an additional 4, 5, 6 meetings the following week over a day, 2 days. So I really hope that the committee sees the good faith that I'm acting in here and asking staff for the review. And we have to update some of the terminology anyway, because we had staff changes.
Okay, so we have this motion on the floor to, I won't ask it to be read out, but basically said the policy pack to be reviewed for the $50, 400, and how it relates to the act. Clean up some terminology, and third point was rollover. Thank you, rollover. So all those in favor of sending this back to the, okay, staff, so be it. Since we also have the original oral report of the policy for review only, we're going to just accept the receipt of the that. All those in favor? Oh, sorry, you have a question before we go? Please do now.
Through you, Chair. I did have a question on 6.5 in the report. I just wanted clarification on the naming of the award, where it states that the award. Can you explain the reason of why the need to the title of the award? Is it is it that we have to name the award that?
Yeah.
Oh, you don't have it in front of you?
6.5, are we talking of the?
For the bursary.
I'm looking at
meeting
the agenda, it's like
attendance of 6.5, but yeah.
I'm confused. What are we talking?
Oh, sorry.
My God.
They put the wrong thing. The wrong thing. It was under
It's an award?
board.
Let me just search.
I put the wrong thing.
650?
650.
Trustee Malley got $200.
Yeah, 650.
Okay.
My
So
apologies.
please restate the question so
Yes.
everyone's on the same page.
In the name of the award, can you please explain, give us help me understand? Is it that we are required to name the award that, or is it that we have the option in naming the award? And how would we name the award?
Through the chair, we can take that back and incorporate it into the review of the policy as well, and provide more context.
Okay.
That it could be something that's historically been in place.
Okay. Thank you.
I've never given
Can't name my school after my mom, so maybe I can do that. Oh, gosh.
Okay, so we got that put out there as another feedback, and any other things we're gonna have a conversation about? Seeing none, all those in favor of this oral report on the policy, so approved. I think that takes us to the end. There are no motions, there are no communications, there are no notice motions. So we're going to put this on the floor for adjournment. Trustee Davis and Trustee Alves, all those in favor of adjournment? Thank you.